Greater Los Angeles. I'm Joyce Batten from the Valley Unit, and we're very glad to have all of you here with us today. Since our programs are open to the public and we've had a very large response to today's program, I'm assuming that some of you in our audience may be new to the League. So in just a few words, I'd like to introduce you to who we are and what we do. Our organization dates back over 100 years when the 19th Amendment to the Constitution was ratified and women won the right to vote. The League of Women Voters is a nonpartisan political organization. We encourage informed and active participation in government. We work to increase an understanding major public policy issues and influence public policy through education and advocacy. With that, I'd like to turn the meeting over once again to Linnea Gwynn, who will introduce our speaker. Linnea.
Thank you. Today I'm introducing Judge Jeremy Fogel, our distinguished speaker for the League of Women Voters, Greater Los Angeles. Judge Fogel is a former United States District Judge. He served on the United States District Court for the Northern District of California between 1997 and 2018. He presided over federal criminal cases, including perjury, fraud, bank robbery, and child pornography. Other cases involved medicinal marijuana, the sale of Nazi paraphernalia on the internet, and capital punishment in California. He has recently spoken out about the need for the Supreme Court to have a public, transparent code of ethics. Since 2018, Judge Fogel has been the first director of the Berkeley Judicial Institute. The Institute is a center at Berkeley Law School. Its mission is to build bridges between judges and academics and to promote an ethical, resilient, and independent judiciary. Judge Fogel is a graduate of Stanford University and Harvard Law School. Today, Judge Fogel will speak to us on the topic, what exactly is the rule of law? How concerned should we be that it is under attack? Judge Fogel.
Thank you very much for the introduction, and thank you to the League for this opportunity to speak with you. I'm very, very pleased to be here. And it's something I tell other judges and retired judges when I speak to them, we need to do more of this. We need to speak to public organizations. We need to speak to people who aren't lawyers and judges about what's going on with respect to the rule of law in our country, because it's really a unique and very challenging time. I have a slide deck, which I'm just going to use as a backdrop, as an outline of my remarks. That really doesn't have a lot of detail to it, but it'll help, I hope, give a flow to the comments I'm going to make. So if we could get those up, I can organize the presentation that way. I just get there we go. Okay, so I'll start. This is obviously the title of the presentation, and I'm going to try to answer the questions that I've asked. And you know, when I talk with people, particularly who are not legally trained, one of the questions I always get is, well, what is the rule of law? What do you mean by that? When people talk about the importance of the rule of law, or the rule of law being under attack, or the rule of law being at the core of a lot of the controversies we're experiencing now. A lot of times people don't really know what it means. And so I thought what I would do initially is just give a very basic definition of what it is. So if I could go to the next slide in the first bullet point. So one of the basics of the rule of law is that you base decisions on evidence and on established legal principles. And you know, it seems kind of obvious, but it's not true everywhere in the world. I've done work in Uzbekistan and in Central Asia, where they are making a very long, but I think sincere effort to transition from Soviet era dictatorship to something resembling a democracy. And one of the things that they've had to deal with is in criminal cases, the habit for decades and decades was the way the decision was made is, well, what did the prosecution want? And there was actually the charade of a defense, but the judge was simply trying to figure out what the prosecutor would be satisfied with in terms of a decision. So the decision wasn't based on evidence, it was based on the desire of the government for a conviction. There was a very notable case, it's one I talk about often, from the 2020 election. And you may remember there was a series of challenges in Pennsylvania to the way ballots were counted there. And one of the major cases went before initially a district judge in central Pennsylvania, and then before the Third Circuit, which is the federal appellate court, which covers Pennsylvania. And both the district judge and the circuit said that there was no basis for challenging the vote count in Pennsylvania. And the decision, and it's the one that really is kind of, it's short and it's remarkable. It was by a very conservative judge who was actually one of the very, very first appellate judges appointed by President Trump in his first administration. And he started out the opinion saying, you have to have evidence to prove things. You can't simply want something to be true. You can't, in this case, say that there had been voter fraud or irregularities and then not present any evidence to back that up. So he started in the very first paragraph of the opinion talking about the importance of decisions being evidence-based. And if the evidence sometimes takes you to a place that you don't want it to go, and the case doesn't turn out the way that if an influential party wants it to turn out, but evidence is the basis of the decision. And right along with that is the idea of established legal principles. So you have statutes, you have prior cases, precedents that the court can rely on. And a judge is trained to look at the facts, the evidence in the case, and apply the law to that, or if there's a jury in a jury trial, then to instruct the jury on the legal principles. So this is really one of the core elements of the rule of law. Next. So equally important is that the parties have an opportunity to be heard. This is sometimes called due process of law. It's the idea that before you make a decision, you give everybody a chance to make their arguments, to say why they think the law and the facts favor their position or their desired outcome in the case. And again, this is not something that's just taken for granted everywhere in the world. I mean, we have a system which by tradition and in practice gives people an opportunity to say their piece and have the court consider their point of view. So it's another core element of the rule of law. Next. You have decision makers who have ethical integrity and effective oversight. So I need to unpack that just a little bit. Decision makers are judges in most instances. In some cases, the decision makers are juries. But the idea is that judges decide the cases that are before them based on the evidence and the law and the arguments that the parties have made, and not because there's an influential party who wants a particular outcome, certainly not because somebody gave them money to decide the case a certain way, or that they're related to someone or they have some personal stake in the outcome. So what I mean by ethical integrity is that the judge is deciding the case in accordance with the rules that apply to the case and the evidence in the case, and not because of some personal reason or some thing that has nothing to do with the merits of the case. That's sort of a simple definition of ethical integrity. And you assume in a system that's based on the rule of law that you're going to get impartial and ethical decision makers. Another thing that includes is that the judges are diligent, that they actually take the time to learn what the evidence is and to learn what the applicable law is. And if you look at the codes of conduct that apply to judges around the country, one of the things that's in there is diligence, that you take your job seriously and you give it your best every day. And by effective oversight, I mean simply that you have appellate courts that review the work of trial court judges, lower court judges, and make sure that they made correct decisions. And you have judicial performance commissions or ethics review boards or various kinds of institutions in every state and in the federal system as well, where, with one important exception I'll talk about in a minute, where the work of judges can be reviewed not just for compliance with the law, but also to make sure that there weren't any ethical breaches. So the ethical integrity is a very important part of the rule of law. Next. And then this one, and I think really in the modern moment, this is so important, and it's that if you go to trial or you argue a case in court and you lose and you don't like the way the case turned out, and you think that the outcome was unfair or inappropriate, you can appeal that, you can complain about it, you can make your criticisms as public and as loud as you want to make them, but ultimately we follow the rulings. And of course, the ultimate example of that in our lifetimes was Bush versus Gore in the case after the 2000 election. And you know, it was an extraordinarily close election. It was decided by about 500 votes in Florida, and there were plenty of people who thought that that it should have gone the other way, or that there were issues that didn't get addressed, or that the decision by the Supreme Court wasn't the right one. But people accepted the ruling. There was not disregard of the ruling. There were not military uprisings or things like that. We accepted that we have a rule of law, and even if the decision is a very, very consequential one as it is there, and it goes against us, we ultimately respect the decisions of the court. Next, please. So, you know, I've described what the rule of law is, and it's not perfect. There are challenges that are baked in to the way we do things, and I want to just describe what some of those are, and they apply to each one of the points that I just identified. Next. So we have evidence-based decision-making, right? So we agree that the appropriate basis for decision in a case should be, what are the facts? What is the evidence? But no person's perception is perfect. What we think the facts are in a situation often varies based on who we are, what our life experience is. We all have, I think, it's fair to say, we all have unconscious assumptions that we make about things. We all have biases, and I'm not using this word in a pejorative sense. I'm using it kind of in a psychological sense, that we all have ways of looking at things that grow out of our life experience. And since none of us have lived everywhere and have had every kind of life experience, sometimes we miss things. So the process of determining what the evidence is sometimes is not perfect. And it's why you can have a jury trial where they get the same evidence presented to them, and you can have a hung jury, or you can have different results in different cases with very similar facts, or you can have judges who see the same facts differently. There's a famous case about this where the Supreme Court had a case involving a car chase, and the person was running from the police at a very, very high rate of speed, and had a fatal accident. And the question was whether the police had contributed to the death of the people who died because they were chasing the car in the way that they were. And you had a video of what had happened, and the Supreme Court split as to what had happened. They actually characterized what had happened differently based on their particular frame of reference. So it's imperfect, but we really do try to make decisions based on evidence. Okay, next. So the opportunity to be heard. We have a core value in our system that people have a right to be heard. But as anyone who's ever been to court knows, it's very expensive to go to court in our system. A lot of people can't afford to. In certain kinds of cases, family law cases, for instance, a majority of the cases, a significant majority of the cases, at least one of the parties doesn't have a lawyer. And sometimes people just can't take off work. We learned something during COVID that when people could attend certain kinds of civil proceedings like debt collections and evictions and things like that, if they could attend them on video, they actually showed up for them, whereas if they had to go to court and take off a day of work to appear, they couldn't. So economic inequality, the lack of availability of representation for people, all of those things fit into a less than perfect opportunity to be heard in our system. And sometimes you have overburdened courts. You have just courts that the caseloads are too high and the judges don't have enough time to give to each individual case. So there's an inherent challenge that if your idea is that everybody should have access to the courts and an opportunity to be heard, this is another area where we're not perfect. Next. And, you know, I mean, I said I was going to come back to the issue of judicial ethics, and I'll talk more about this later and I can answer questions about it. But, you know, you want judges who really take ethics seriously and who really work at it and make their best effort in every case to be as ethical as they can be. But, you know, people are different, and sometimes the standards for selection of judges don't always get you the very best people. Most of the states actually have judicial elections, and for trial level judges at least, and that can lead to politicization of the process. It can lead to people getting elected to judgeships who are good at campaigning and not necessarily good at the job of being a judge. So we have a less than perfect selection process, and then oversight really is very inconsistent. There are some states, I'm happy to say California is one of them, where there's a pretty robust process of oversight for ethical mistakes that judges make, but some states don't have that. The federal side, it's quite inconsistent because most federal judges have life tenure, and so the only way you can remove them is through impeachment and removal, and that very, very rarely happens. And so the leverage to deal with misconduct is pretty limited, which makes the selection process that much more important. You want to be sure you get really good people. And then, of course, as was evident in the last couple of years with the debate about the Supreme Court and ethics, they just within the last year and a half adopted a code of conduct, and they don't have an oversight process at all. So, you know, you really are depending on the selection process being one that gets you people who take ethics seriously. So that's another inherent challenge that we face. Next, please. And then, you know, this is something that, why I said at the beginning, I think it's so important that people like me and judges talk to the community, is that, you know, law, like medicine, like a lot of other fields, there's a special language. There are a lot of inside the silo ways of talking about things and thinking about things, and the more we can be transparent, the more I think people can understand how a decision got made and are more likely to accept it, even if they disagree with it. You know, I had it was mentioned one of the cases, one of the issues I was involved in some depth when I was on the federal court was the death penalty, and that's obviously a very controversial subject, and people have very, very profound feelings about it. And every decision I wrote, I really tried to acknowledge that it's a divisive issue, that people have very strong feelings, and that the issues that I had to decide were discrete, and they were actually fairly limited ones. But you have to acknowledge, you have to be transparent in dealing with the public through decisions, and I think this is something judges could do better. So there's an inherent challenge there. Next. Okay, so that's kind of, you know, the big overview. I want to talk about where we are now. So we are facing some unique challenges in the present moment, and I'm sure that's why I was invited to give this talk. And I want to preface it by saying I have spent my entire professional life being as nonpartisan as I can be. I'm not about to change. I think it's very important that judges not be partisan, and just the fact that I'm retired and I'm not hearing cases anymore is not something I'll suddenly flip a switch and decide to be a partisan advocate. I think I'm trying to do the best I can to say things that apply across the board and are going to make just as much sense to a conservative Republican as they will to a liberal Democrat. So I hope I approach that aspiration here. So what are the challenges we're facing? Next, please. So we are hearing rhetoric in some places, and it's not like everybody is saying the same thing, but certainly some administration spokespeople are saying that the outcome of the case is actually more important than the process by which the decision is made, the evidence-based approach, the application of the law, and that if the judge doesn't reach the desired outcome, that it means that there's something really wrong with the judge. So it's criticism that isn't principled. It's not based on the judge made a legal error. The judge got the facts wrong. The application of the law to the facts was not done in the right way. It's just saying, we need to do this, and the court made a decision that's getting in our way, and therefore that was a bad decision. And there have been some statements to that effect, and there have been probably more statements to that effect in the last couple months than has been true for a very long time. And there's always controversy about the courts. And I was talking to a friend of mine today who's a scholar in this area, and he said, we've had many periods in the history of our country where the courts have been challenged, and the role of the courts has been challenged. But there's a certain frequency and passion to the rhetoric now that is definitely one of the things we have to come to terms with. Next. Something, and I'm just going to be very candid because it'll come out anyway, that I'm quite concerned that there have been threats and even executive orders directed at law firms that represented people who opposed the current administration in the past, that they filed voting rights cases, or they filed other kinds of litigation. And it's that the lawyers who did that are being targeted, that their firms are being banished from courthouses and being told that they can't have government contracts, and that their clients are being intimidated. There was a major firm in New York, Paul Weiss, that had to make or they felt that they had to make an agreement with the government to make some significant concessions so that they would not be blacklisted. So this is a challenge, again, that is new and different and quite concerning. If you think about it, I don't know if any of you know people who have been public defenders or court-appointed defense lawyers, and sometimes there's a question at a dinner party or something, and someone will say, well, how can you represent somebody that you know is guilty? And the answer is because they're entitled to a defense, because under the Constitution they have a right to legal representation. And if you only represented people that you believed were innocent, then a lot of people who are charged in criminal cases wouldn't have representation. So there's kind of a built-in imperative in our system that gives lawyers who represent people, even in unpopular causes, gives them a certain safe harbor, a certain kind of protection. So this is something new and different that we're facing in the modern environment. Next, please. There have been some very loud and well-publicized threats to impeach judges who have made adverse rulings. And I think there's about 5 or 6 now. I think we can go back just a little bit. One more. Thank you. Yeah, one more bullet that we. Yeah, so, whoop, sorry. No, we gotta go back the other way, sorry. Okay, you can stop right there. That's fine. So there have been the efforts to impeach judges. I have to say, and I'll anticipate a question, I don't think any of them are going anywhere. It takes a majority of the House to impeach a judge. It takes 2/3 of the Senate to convict a judge and remove them. There has never been, in the entire history of the United States, a judge removed for making an unpopular decision. There's been one judge in the long history of our country that was impeached by the House, but he was acquitted by the Senate. And it's an interesting story. This was a Supreme Court justice named Samuel Chase, and this happened in 1804, so a long time ago. And Thomas Jefferson had just become president. His party was riding high. They had a supermajority in both houses of Congress. And Justice Chase ruled against the Jeffersonians in a number of cases. It was more than one. And the president wanted to get rid of him. And he was impeached. And basically, the argument for impeaching him was that his decisions were contrary to the will of the public as expressed in the election, which is what's been said about the current impeachments. And he was impeached by the House. He's the only one who ever was for something other than a crime or bribery or something like that. And he got to the Senate, and it looked like he was going to be convicted by the Senate because the Senate had a 2/3 Jeffersonian majority. And there were about a half a dozen of them who did not vote to remove him. And they said at the time, and this is, 220 years ago, they said, we don't want to set the precedent of removing a judge just because we don't like their decisions. I mean, the impeachment of judges and removal of judges should be for misconduct, such as taking a bribe or assaulting somebody. If you look at the 8 judges who have been removed through this process in the course of time, they've all committed felonies. So really interesting history. It's a bit of a geeky reference, but the Chase case really gets to that point. That's all that said. If you're a judge who one of these charges has been made against and are threats to impeach you, that is not something helps you sleep at night. I mean, that puts a tremendous amount of stress on the judge, just thinking about, well, are they going to follow through with it? Am I going to have to hire counsel? Am I going to have to appear in Congress? So it's not something that you can just shrug off. Okay, next, please. And then this one, I think there probably, again, maybe along with the threats to the law firms, that the threats to judges' personal safety and their families' personal safety. There was a matter that I had a particular interest in because it was a case that I was asked to comment on in the media, and I did. And it was a case where the Supreme Court, by a 5-4 vote, had did not stayed one of the restraining orders that's been issued against some of the current budget cutting policies. And the Chief Justice Roberts and Justice Barrett joined the 3 liberal justices of the court in voting that way. And within a couple of days after that, Justice Barrett's family, she has a large family and she had relatives who live in Louisiana. Some of the members of her family were physically threatened because of her vote in this case. And you sort of put this in context, it was not even a decision on the merits of the case. It was a decision on a procedural order and just what was going to happen while the case was pending so that the Supreme Court could consider it at a future date. So that's quite concerning. And then there have been threats of noncompliance with court orders. There's a pretty well-publicized struggle going on right now in Washington, D.C., where I spend a lot of my time about the deportation flights and Judge Boasberg's order that they not take place, and at least 2 of them did. So there's a battle going on currently about that. But it remains to be seen, really, whether there will be actual refusal to comply with court orders. We haven't quite gotten to that point yet. So that's quite a list of personal challenges. Okay, next slide, please. So how concerned should we be, right? That's my other question. And I've got some thoughts about this. Okay, number 1. So this is an unprecedented situation. My judicial career began in 1981. So that was 44 years ago. I've never seen anything remotely approaching this. I was talking with my scholar friend this morning, and he said there have been other times, one even as recently as the 1990s, where there was an effort to kind of roll back the courts. There was an effort to impeach Chief Justice Warren in the 50s after the Brown versus Board of Education case. There have been other stirrings of this type of sentiment in the past, but not nearly with this intensity, not nearly with the sort of this much public debate. And I think some of that certainly has to do with social media and the way people get news, and the whole nature of the world we live in today, and the polarization, the hyperpolarization. And that's why I said you have to go back to the Civil War to see anything even remotely suggesting it, because obviously at that time, people were either pro-slavery or they weren't, and so many things got seen through that lens, and there certainly was a tremendous amount of controversy that ensnared the judiciary. But it's been at least that long. Next, please. One of the things that concerns me, I have had the great privilege of representing the United States in some foreign delegations aimed at helping other countries strengthen the rule of law. I mentioned being in Uzbekistan. That's been really interesting work, and that's a country that's actually made a lot of progress. But some of the other places that I've been that were democratic to a greater degree in the recent past, and within our current memory, have become more authoritarian. I've cited a couple here: Turkey, Poland, Hungary. These are all still nominally democracies, but what has happened in all of those countries is that an authoritarian government or an authoritarian-minded government attacked the judiciary. And the one that I feel most comfortable talking about is Turkey, because I was there a number of times and worked with their judicial education college. They really were, I think, for a while, trying to be a beacon of democracy and inclusion and pluralism in that part of the world. And at some point that shifted. And one of the things that the current leader did was go after the judiciary. And he fired judges who was in a position to fire. He fired the entire leadership of the Judicial Academy. Did a lot of things, put some judges in jail. I mean, there were some very, very strong efforts made to get the judiciary to be more subservient, and it is, and it's succeeded. And I would not call Turkey a very robust democracy at the moment. And I'm not trying to offend anyone. I think it's just an objective observation. The same thing happened in Poland. It's come back somewhat under its current government. Hungary is one where I think it's still a pretty strong authoritarian trend. So the judiciary has played a role it's provided guardrails, it's provided a sense of balance, checks and balances, and authoritarian leaders, authoritarian playbook often involves weakening the judiciary, delegitimizing the judiciary. And I think that's certainly something you could draw from the current circumstances that we're in. Next. This is a point that's made often. One of the things I've always liked about the League of Women Voters is that it's an organization that's dedicated to civics education and keeping people informed and people making intelligent decisions in the political sphere. But there really has been a decline in people's knowledge of how things work, how the three branches of government interact with each other in our system of government. Some of it is just a lack of civics education in school, a lack of other ways to get that information, the way people get news. People don't get news as much from legacy media. They get it from podcasts and from social media and from TV sources that are very one-sided. And I think both right and left are guilty of that. And so it's very hard to get a real accurate picture of what's going on. And so I think a lot of people think that judges really are just politicians in robes. I mean, that is that stereotype. And they don't have a lot of counter information to that characterization. I was trying to figure out how many judges I've known in my life. It's certainly in four figures, if not five. And number who I thought were politicians in robes, very few. There are some. I mean, I certainly have known some who saw their job as to be, being activists for their particular viewpoint. But most judges try to play it straight. Some succeed better than others, but I think that stereotype is largely unfair. Next. So I've given you all the bad news. I'll tell you a few things that make me optimistic, and then I'm really looking forward to your questions. Reasons for optimism. So we have constitutional guardrails. Judges have life tenure. You can't fire a Article 3 federal judge, Article 3 being the article of the Constitution that created the federal judiciary. There was some talk just in the last couple of days that Congress could abolish some judgeships, and they actually do have the power to reduce the number of authorized judgeships or increase it, but they can't remove a judge who's currently sitting, because those people have life tenure under the Constitution. Now, if you get a bad apple, that's too bad. I mean, then you're really stuck with somebody for life, and that's not a good thing. But in my mind, to a great degree, it gives you a tremendous amount of protection. You have decisional independence. You can make an unpopular decision. You can't be fired. People can carry on and say, we're going to try to get you impeached and this and that. But it actually does provide a guardrail against the most extreme types of delegitimization of the judiciary. I don't think, I said this at the beginning, and I'm just making a prediction, but I think it's based on some knowledge, that I don't think any of these impeachment threats are actually going to be followed through on. I think they're performative rather than serious. Next. So related to this, you really can't underestimate culture and tradition, And again, I think about some of the other countries I've talked about. One of the struggles in Uzbekistan is they've been trying to have a more rule of law based legal system. Is that they're just not used to it. That they had absolute dictatorships for so many decades. I mean, there was the Soviets, and then there was the Karimov regime, and the current regime, and just the idea that you could actually try a criminal case and lose it. That there were prosecutors who were old-time prosecutors, just couldn't believe that the defense would ever win a case, and they were very frustrated when that started to happen. So culture is very powerful. Even in Turkey, and they made a lot of headway, I think, toward democracy. But before that, they'd been the seat of the Ottoman Empire, and again, a very much a authoritarian culture. So that's different about the United States. I mean, we have a culture of where rule of law is important. We have a culture where judges are treated respectfully and seen as leaders in the community. And yes, that can be attacked, and there can be efforts made to delegitimize it, but there is a certain staying power in the culture that we have, and I don't think we should underestimate that. Next. There has been a tremendous response in the legal community to the current threats to the rule of law. Bar associations all over the country, judges groups all over the country, retired judges joining Friends of the Court briefs in various cases, people speaking where they can to the media. My life has been kind of nonstop. I get up in the morning, and I can't dare not look at my email, because there's going to be some reporter who wants to talk about this general topic, and I can do it because I'm retired and I am not constrained by the code of conduct. So there's a lot of focus on this situation among lawyers and judges, and that makes me optimistic. People are really taking it seriously. Next. And then, and last, and we'll just hopefully have some questions, but I think programs like this are really important, and the fact that you all wanted to have the program makes me optimistic. I mean, people see the issue as one that's important, and that one needs to get educated about and figure out what to do about. And I think as long as that's true, that I'm going to continue to be optimistic. And I have to end by acknowledging that I am congenitally optimistic, and sometimes I'm wrong, but I think that there's a lot of resilience in our commitment to the rule of law, and I expect it to show itself over the next months. Okay, I'm ready for questions.
Yeah, I would like to start off the questions. Very recently, of course, we've seen this issue where the administration has just bundled off a bunch of people and sent them down to Salvador, and without any kind of process at all that is visible to anyone. And we would like to, I think this is something that is, I've never seen anything like this at all, of course. And it just seems to me that this, in the case, the judge has told them, bring them back, turn around the plane, and they were completely ignored. And so this also creates a problem with how judges' rules are enforced. And would you comment on that?
Sure. Well, I'm happy to talk about that case. It's troubling in a lot of ways. I think the judge is still trying to figure out what happened with those airplanes, and I think that I want to give him a lot of credit because he's being very deliberative in the way that he's doing it. He clearly is more than a little concerned about what happened, but he's giving the administration every opportunity to explain what happened. And they've not taken that opportunity, at least not in any way that I'm aware of. And that kind of has created a procedural standoff. There was a ruling today by the District of Columbia Court of Appeals, which oversees Judge Boasberg, and they upheld his issuance of the temporary restraining order. They haven't reached a final decision in the case, but they validated what he did. It was interesting. It was a split decision. It was a 2-to-1 decision. The dissenting judge said not that he was wrong about the statute, but that the case should have been brought in Texas rather than in DC, because that's where the deportees were taken from. But that case is a real litmus test. So far, there's been no final determination as to whether what the government did was a contempt of court or not. I think there inevitably is going to be one. There has been a determination that the judge's order restraining the deportations was correct, or not reversible anyway. That it was something that the Court of Appeals sustained. I think it's almost certain that the administration will take that to the Supreme Court. And the Supreme Court doesn't have to take the case. I don't want to make a bet as to whether they will or not. My guess it's about 50-50. I could see reasons why they would and reasons why they wouldn't. But this goes back to something that happened in the 1820s. You go back 200 years, and remember that around that time there was the deportation of the Cherokee Indians from their native homeland to Oklahoma. It was the Trail of Tears, and there was a court order that not occur. And Andrew Jackson, who was the president at the time, said, well, Chief Justice Marshall has made his order, now let him enforce it. And they went ahead and did the deportations, and nothing happened. And I believe that President Trump actually referred to that once as something that he approved of, that he approved of what Andrew Jackson had done. So I think we're heading for a constitutional clash here. We already have one, but I think it's going to come to a head. I think the judge is being extraordinarily patient in making the best record that he can make. And this goes back to some of the points that I was making before. He's not just going to try to throw a lightning bolt back from the bench and say, you know, I told you to turn around those planes and you didn't, you know, so that's going to be 30 days in jail. I mean, he's doing it by the book and making sure that all of the I's are dotted and all the T's are crossed. And I think that's appropriate in a high profile case. So I hope that answers your question.
Yeah, there's lots more coming, I think, here. We have, let me see, one is, it looks like the United States government will owe a tremendous amount of attorney's fees and damages in cases that are arriving from the administration recent behavior, illegal behavior. How can payment be assured, and how soon can people expect payment?
Well, that's in a way, it's related to the question I just answered. I don't think anything is going to be done by agreement or accommodation. I think everything will be litigated to the nth degree. I think I described this strategy as being one, let's just throw things against the wall. Let's constantly throw things against the wall. Let's push things as hard as we can. Let's see what we can get away with. Let's see how far we can go. And what it's like, it's a tremendous stress test to the legal system. And we'll see how well the legal system holds up. I actually think it's held up pretty well so far, but it's early. And I think a lot of these struggles and a lot of these conflicted cases are going to take time to play out. And I don't think anybody's going to get paid anything for a while because the cases are still being resolved. I think what's really going to be interesting is if the administration loses those cases and is ordered to pay fees, and if people are entitled to back pay or whatever, you know, then what's going to happen? I mean, we're actually going to have a outright refusal to comply with a court order. But I think until all appeals have been exhausted, I think it's too soon to know.
Now we have a question about the way that the president has been issuing threats against law firms and essentially preventing one from even having their attorneys be able to be admitted to federal buildings, and a settlement where a law firm ponied up some tens of millions of dollars and agreed to do work for the government pro bono. You know, is this really, how is this, how do you see this shaping out? Are law firms going to cave in like this?
I think I mentioned this in my remarks, that I think, to me personally, this may be the most concerning thing that has happened, because it really goes to the whole idea of people being able to have their day in court. I mean, it goes to access to justice. And it's interesting with the law firms. The one law firm did cave, and they agreed to do $40 million of work for the government pro bono. I have heard them say, and I've heard the chairman of the firm say that they did that because if they hadn't done it, the firm would have failed. I mean, it would have destroyed the firm. They would have lost too many clients. So that the pressure was just, they could not resist the pressure. I think that's a very, very upsetting, very concerning thing that happened with that firm. There is another firm, it's based in California. Well, actually, it's based in Seattle, but they have a big presence in California, where they are taking exactly the opposite approach, where they're refusing to abide by the order. They filed suit. They got a restraining order from a judge in Washington, D.C., saying that they could not be banished from courthouses, that they could not be forced to stay away from federal work, and that the entire executive order was unconstitutional. That case is being litigated in D.C. I know that there is a group of retired judges, and I should disclose I'm one of them, who have signed on to a friend of the court brief in that case, urging the court to continue to prevent the order from taking effect. So this is a law firm that decided to resist that. And I think there's a range of responses, but it's law firms are in business to make money, and some of these firms are real high roller firms. I mean, their lawyers charge a lot of money. They represent very prominent clients, and losing access even in the short term, or losing the favor of federal government in the short term. The Paul Weiss firm in New York made the decision that they simply couldn't afford to take the hit. So I think, I mean, of all the things I've talked about today, this is the one I'm probably the most deeply concerned about.
Yeah, and there's also a question about the ethics of the Supreme Court. And though they recently did pass an ethics, standard, there isn't any indication that there's a way to enforce it, and it seems like it is still being ignored. Is that?
Yeah. Well, all right. So again, disclosure, was actually pretty deeply involved in that whole thing, and so what I'm going to say now is somewhat informed by that. Before I came to my current job at Berkeley, I was the director of the Federal Judicial Center, which is it was during my judicial career. This is the agency that does education and research for the federal judiciary, and it's based in Washington, D.C. And I was the director for 7 years. I worked with the Chief Justice directly. He was the chair of my board, and with various members of the court. And I remember raising this issue when I was there at the FJC, saying, how come the Supreme Court doesn't have a code of conduct? All the other judges in the country have one. And I was told that they didn't think that they needed one. That they consulted the other codes, and they did their best to act ethically, but they didn't think there was a need for a specific code of conduct. And they certainly didn't think there was a need for anybody to have oversight over what they did, even though all the other judges in the country have that. And then when the controversies around some of the justices came up, there were some particular ones involving Justice Thomas and Justice Alito, but there were actually controversies involving a majority of the justices, sort of lesser ones, less well publicized ones. And so the Senate started having hearings, and they asked the chief to come and speak, and he said, I don't really think there's anything for me to say, but he submitted a statement by the court saying that they didn't think they needed a code of conduct. And so then the hearings were held. There was a lot of publicity about that. A lot of people weighed in. And at the end of the day, it was in November of 2023, the court reversed itself, and they did adopt a code of conduct. The code of conduct that they adopted is not the same one that applies to judges of lower courts. It's not the same one that applied to me when I was a federal judge. It has some of the same principles in it, the same general aspirational goals, but it's much less specific, and there are some amendments to it. There are some changes in it from what applies to lower court judges, particularly around disqualification and recusal, because the argument that they were making was that there's only 9 justices. There aren't any procedures for replacing a judge who can't sit because of a disqualification. So you have to have a more lenient policy about recusal. And there were also some exceptions in there for some of the things that justices do. It was like going around the country and speaking to groups about their work. In any case, they adopted this, and one of the things that was pointed out immediately was that there's no enforcement mechanism, that it was still, here's the code, and they're just saying we're going to agree that we're going to live by these principles and follow them, but there's no procedure for reviewing situations where judges don't, or justices don't. And that was a criticism a lot of people made. There was some effort, and this is where I was involved for some months, of trying to get them to have an internal review procedure where they would have a confidential group of senior judges from either retired Supreme Court justices or retired chief judges of courts of appeals, but be like I call it a council of elders, but just a body of people who had a lot of experience and were seen as really strong on ethics and very nonpartisan, that they could at least ask, they could get advice from in close cases. And I think that was actually making a little headway. A couple of the justices actually endorsed the idea publicly. But then when the election went the way it did, I think the momentum for any changes in the ethics code went away. And you would need there to be, I think all 9 justices ultimately would have to be on board for it to be meaningful. I think they take the position that constitutionally, Congress could not impose an oversight body over the Supreme Court because the Supreme Court is a separate branch of government. And whether that's true or not, I mean, that is their view. And I think just about all the justices believe that. I think there's a sense that it would have to be something they did voluntarily. And I still hope, in time they will come back to the idea of something. In the meantime, I can't think of any ethics controversies involving any of the justices recently. I mean, it's been overshadowed by other news, but I think one positive effect of all of the controversies that did occur is that I think the justices are being more careful. And I think that's some small consolation.
And then I have another question here that should the president if the president refused to accept a Supreme Court decision, what do you think would happen? Is there an enforcement option?
Well, the way the Constitution is constructed, what would be expected to happen, if you go back to what the framers were thinking in 1789, if that happened, then the president would be impeached and tried for not following a lawful court order. And the reality is that given the current partisan makeup of Congress, it's very unlikely that that would happen. But I mean, I think that's the structural enforcement that's there. That if the Supreme Court tells the president, you have to do this, and if you don't do it, you're gonna get impeached, and you're gonna get. This is exactly what happened with President Nixon. So you have to go back in our memory too far. I mean, go back to it's hard to believe it was 50 years ago, but that's what it was. It was 50 years ago, and if he had not turned over the tapes when the Supreme Court ordered him to do so in a unanimous decision, if he had not turned over the tapes, then he would have been impeached and removed, even though a lot of, there were enough Republicans in the Senate to prevent conviction, but they came out and said, we're not going to vote for you. I mean, this is sort of just a statement of how the times have changed, because even though things were pretty partisan, they weren't that partisan. There were lots of people. I mean, I think about names that'll ring a bell to some people, like Barry Goldwater. Not too many more conservative senators than him, and he said, no, I'll vote to remove you if you don't turn over the tapes. So, and then of course the tapes were what they were. So yeah, that's what should happen. I don't have a lot of confidence that would happen today.
Another question here is what would you give us your thoughts on the proposal to enlarge the Supreme Court, give more justices and maybe an 18-year term limit for active judges?
18-year term. Yeah, thank you. I like that question. So I am in favor of term limits. I think the process of choosing Supreme Court justices has become way too political, because you are, and they're looking for younger and younger people. The last several appointees have all been in either their late 40s or early 50s, and I think it could even get younger than that, in time. But the idea is to find young people and imagine that they're going to serve for 40 years. Justice Thomas was in his 40s when he was appointed, and he's been on the court for almost 40 years now. So I think having life terms and having such a politicized nomination process, it's just not I don't think it's good government. And I think if you had a 18-year term, it would serve certain purposes. The proposals I've seen is that you would stagger the terms. So there would be a new justice appointed every 2 years, whether or not there were vacancies caused by other reasons. But that means that you'd have no more than 2 justices appointed between elections. And it would prevent any one president from stacking the court unless that president was elected to 2 terms, in which case you would assume that the public wanted more of what that president was offering. I also think it would make it much less important to get people who are really young. You could get justices who were older, knowing that they were only going to be able to serve for 18 years. And I'm not saying that they necessarily would be better, but I mean, it would just take some of that pressure off. I think you could do it without amending the Constitution. I mean, there's been some discussion of that. I think as long as those people continue to be federal judges after their 18-year term was up and they had some sort of senior status, that it would still be constitutional. So I think term limits are a good idea. Expanding the court, I have very mixed feelings about. If we were starting from zero, if we didn't have a constitution, or we didn't have 9 justices, and we were just kind of beginning, and so we have a country that has 400 million people, and all these different regions and states and interests. How big should the Supreme Court be? I would say it should be bigger. I mean, I would think it ought to have maybe 15 justices. You know, it's just that having 9 people be responsible for this degree of power, it troubles me. And if you look at our sister countries that have similar populations or similar social development, Canada has the same number of justices we do. It has far fewer people than we have. But if you look at England or Germany or France, countries that are very evolved, that very strong judiciaries, they have a lot more justices on their apex court. It's just the idea you get. You're not putting as much weight on each individual person, giving each individual person that much power. Because now you just have 5 unelected people can tell the whole country what to do. You just need a majority of 9. So that's my academic answer. My practical answer is that if you were to expand the court from 9 to 13 or 15 or whatever it is, it would be just as easy for the next Congress, once power shifts, to expand it further or to reduce the size. I mean, there's nothing magic about 9. I mean, we haven't always had 9 justices. We actually had at the beginning of the Republic, we had 6. I don't know how they did it because they didn't have an odd number, but there were 6. And so it's something Congress can do, but I think you have to really think about how to avoid the political tit for tat. And I think that's the biggest disincentive to expanding the court.
And another question here is that what sort of special roles should nonprofit organizations or political organizations play in the enforcement of the rule of law?
Well, I think now they just need to be outspoken. And I could say a lot about this. I think, and one thing is sort of just showing up and saying, we don't like the attacks on the rule of law. We don't approve of them. It's not about whether we like this president or not. It's not about which party we like. It's that this is it's a structural attack that is just not good for the country. I've been particularly appreciative of conservative people and conservative organizations that have spoken up and said exactly what I just said, because I think it's harder to paint them as coming from a partisan place. But I think that's something that nonprofits can do and should do. I think one of the things that sort of a cautionary note there. I've spent, because I've been speaking out about this stuff a lot, I talk to a lot of people, and I get a lot of angst from people. I get a lot of worry from people, and it's not surprising, but I mean, it's just people think the sky's falling, that, this is, the end of civilization as we know it. And, we're 2 steps away from fascism or worse. Well, I hope it was clear from my presentation. I think things are bad. I mean, I don't think I wouldn't want us to be here, but I think you have to be measured. You have to think about, well, where are we now, and what can we do? And some of the stuff I've read, some of the statements I've read have been awfully incendiary. They've been angry. They've been condemnatory. They've had a tone which I don't think is the best way to deliver this particular message. I mean, this is really existential for our country, that are having a system that's based on the rule of law, having a strong judiciary. I mean, I think it's really important, and I think you can say that, and you can support that point of view without getting in the gutter. So I think that's my other comment to that question.
I know we're running short on time, but there is one question that seemed pretty interesting to me. How far can individual taxpayers go in standing up to ensure that the government properly and expeditiously spends legally allocated funds for their intended purpose?
Yeah, that's a great question. So taxpayer suits are there are laws that permit them. There are False Claims Act. There are statutes that permit individuals to do things like this, and it depends on exactly what the claim is. I think I've lost track. I think there's sort of upwards of 50 cases going on right now, but at least some of them actually do have that basis. So they aren't just trying to block actions that the administration is trying to take. They're trying to enforce expenditures that were authorized. I think there will be undoubtedly some litigation. I think it's already started about the Department of Education, for instance. It's a cabinet department that's authorized by Congress, and so to just shut it down, I think there will be legal challenges to that. And the theory of those challenges will be that these are lawful appropriations, and the administration can't just impound the money. And I think that's another one of many issues that's going to get tested over the next few months.
Are there cases filed on that already?
Yeah, I think so. I mean, as I said, I don't have all 53 of them in my head, but I know that is one of the legal issues that's going to get. And this is a sort of part of my larger point. I mean, a lot of these, all we've got so far is preliminary rulings. We have temporary restraining orders, which are just orders by the court to keep the status quo in place. We have a few preliminary injunctions, which are just a little bit more permanent, but still preliminary, right? We have not had final determinations of a lot of the legal issues that are being contested. And I think those are going to take several months, because they have to go through the trial courts, and then they have to go to the circuit courts, and then the Supreme Court has the discretion to take as many of those cases as it wants. I don't think they can't take all of them, and they aren't going to take all of them, but they're certainly going to take some of them. And so it's going to take some time for that legal process to play out, which is why I think this, we're going to have this situation for a while.
Well,
I think
I think
yeah, I was going to say, I think we probably, go ahead.
You've been very generous with your time, and we appreciate it. I'm sure in 2018, when you became the executive director of the Berkeley Judicial Institute, you did not imagine this scenario.
No, I didn't think about that.
But we're grateful to you that you are playing this role. And in the League, we are supporters of the rule of law through many different channels. So thank you. And we wish you well, and we're appreciative of your continued dedication.
And the same to you, and thank you again for inviting me to do this. really, really enjoyed myself, and thanks so much.
Thank you.